Keep walking, and I will make sure you never set foot in this county again. Your kind always thinks the rules bend for you. They don't. Not here. Not in my jurisdiction. The man who said those words did not shout them. That was what made them land so hard. Deputy Darnell Pike spoke them the way someone reads a grocery list. Flat, practiced, entirely certain of his own authority. He stood at the entrance of the Calloway County Administrative Building on a Tuesday morning in late October, one hand resting on his belt, the other loose at his side. He was not looking at Simone Cross with anger. He was looking at her the way you look at something you've already decided doesn't belong. Simone did not respond immediately. She stood on the concrete walkway, a worn leather satchel over one shoulder, a paper cup of coffee going cold in her left hand. She was dressed plainly, dark slacks, a gray blazer, flat shoes. Nothing about her announced anything. Nothing about her was supposed to. She looked at the sign mounted to the right of the entrance. It was a standard municipal notice board, the kind that collects flyers for zoning hearings and utility rate adjustments. But affixed to its lower left corner, behind a sheet of scratched plexiglass, was a laminated card. Pike had referenced it when he first stepped in front of her. He had read from it without touching it, the way someone recites something they've memorized from seeing it every morning. Calloway County Administrative Facility, the card read, authorized access required beyond this point. Unauthorized entry subject to detention per posted county notice, effective March 4. No statute number, no ordinance code. Just a laminated card behind plexiglass, and a man with a citation pad who believed that was enough. If you've ever watched someone with a little power treat it like it was everything, stay with this story. And if you're new here, consider subscribing. What happens next takes 18 months, one federal-level credential, and a Georgia county that didn't know what it had started. Simone looked at the card for 3 full seconds. Then she looked at Pike. Then she took a slow sip of her cooling coffee, lowered the cup, and said, quietly and without heat, I'm here for the Public Records Office. The county website lists walk-in hours starting at 8:30 a.m. Pike did not move. Appointment only as of last month. Is that posted anywhere? The pause that followed was small, maybe 2 seconds, but it was the kind of pause that tells you everything. Pike's jaw shifted slightly. His hand left his belt. He reached for the citation pad on his right hip instead, and the sound of the metal clasp snapping open carried clearly in the still morning air. What happened next was not an arrest. It was not a confrontation in the dramatic sense. It was something quieter and in its own way far more instructive about how power operates when it goes unchecked. Pike wrote out a citation for unauthorized approach of restricted access area and handed it to Simone Cross without looking at her face. She accepted the paper. She read it once, top to bottom, folded it in half, and slipped it into the front pocket of her satchel. Then she turned and walked back down the path toward the public parking lot. Pike watched her go. He assumed that was the end of it. He had no way of knowing that Simone Cross had been in Calloway County for 3 days already. He had no way of knowing that she had arrived quietly, on purpose, with a specific reason that had nothing to do with the Public Records Office, though she would indeed need those records before she was done. And he had no way of knowing that the folded citation now sitting in her satchel was not an ending. It was the first piece of paper in what would become a very long file. The morning moved on around her. Cars pulled into the lot. A woman in nursing scrubs hurried past with a tray of coffee cups. A maintenance truck idled near the side entrance. Calloway County, Georgia. Population just under 31,000. Seat of local government for a stretch of Piedmont country where the pines ran thick, and the county courthouse had stood on the same corner since 1922, conducted its Tuesday business as usual. Simone sat in her rental car for a few minutes. She did not make a call. She did not type anything into her phone. She opened the front pocket of her satchel, unfolded the citation, and read it again. Then she took out a small spiral notepad, the kind sold at gas stations, with a flexible black cover, and wrote 3 lines in a careful, compact hand. She did not write quickly. She wrote the way someone writes when they want to be sure, later, that they can read it back exactly. She capped her pen. She looked through the windshield at the administrative building. At the entrance where Pike was still standing, now talking to a second man in a county uniform. At the laminated card behind scratched plexiglass. At the ordinary Tuesday morning going on all around a place where something had been quietly wrong for a very long time. Then she started the car and drove back toward her motel. Simone Cross had been in rooms like the one at the Pineview Motor Lodge before. Single bed, thin curtains, a heating unit that cycled on and off at intervals that had nothing to do with the actual temperature. She had learned, years ago, to sleep through the noise that came with unfamiliar places. She had also learned to use the early hours well, before the day hardened into its shape and people stopped saying the things they would say to a stranger who seemed unremarkable. She had arrived in Calloway on a Saturday, driving up from Atlanta in a mid-sized rental with a half tank of gas and a single bag in the trunk. She checked in under her own name. She paid with a card. She asked for a room on the ground floor, away from the vending machine, and the woman at the desk gave her one without comment. That was the thing about Simone Cross in a new place. People answered her questions and then forgot her. She had a quality of stillness that made her easy to overlook. She had spent years making use of it. Saturday evening, she had walked the 2 blocks to the county library before it closed and spent 90 minutes at a public terminal reviewing publicly available court dockets. She was not looking for anything specific yet. She was looking at shapes, the way data clusters when a pattern is present versus the way it distributes when things are working as designed. What she found on Saturday evening was a shape that interested her, though she did not yet know its full dimensions. Sunday, she walked. She covered perhaps 4 miles over the course of the afternoon, no route in particular, down the main commercial strip, past the consolidated school complex, along the edge of the residential neighborhoods that backed up against the old rail corridor. She stopped at a diner called Maybell's and ate a plate of eggs and toast and listened to the conversations around her without participating in any of them. She ordered a second coffee. She tipped well. She left without anyone remembering much about her, except that she had been polite. Monday morning, she had attended a public session of the Calloway County Commission, the kind of routine administrative meeting that gets posted on a bulletin board and draws perhaps 12 people, most of them retirees or contractors with items on the agenda. Simone sat in the second-to-last row and watched. She did not speak. She took notes in her small notepad, unhurried, using a shorthand that was entirely her own. She noticed the way Camellia Voss, who served as the county court clerk, but who appeared to function, in practice, as the administrative coordinator for most of what happened in that building, moved through the room before and after the session. She noticed the way Camelia's expression shifted slightly when she scanned the unfamiliar faces in the gallery. She noticed that when Camellia reached Simone's row, she paused just long enough to ask, pleasantly, whether Simone had filled out a visitor registration card. Simone said she had not seen one available. Camellia said she would get her one. Camellia did not get her one. Simone noted this in her pad and continued watching. By the time the session adjourned, she had 3 pages of notes and a clearer sense of how authority was distributed in this building. Who deferred to whom? Who spoke first? Whose name came up when decisions needed to be justified? One name came up more than any other. Judge Otis Wren had served as Calloway County's sitting judge for 18 years. He was elected to the bench in a year when the county was smaller, the races less contested, and the name recognition that came from serving 2 terms as county commissioner translated almost automatically into judicial office. He had run unopposed in his last 3 elections. His name appeared on the building's donor wall in the lobby, a modest bronze plate listing contributors to the courthouse renovation project of 2016. His name appeared in the commission minutes whenever a policy touching the court required approval. His name, Simone noticed, was the one that caused a particular stillness in the room whenever it came up. Not the stillness of respect, but the stillness of people who have learned to be careful. She wrote the name at the top of a clean page. Otis Wren, County Court, Presiding Judge. She circled it once, lightly, and turned the page. Tuesday had brought her to the administrative building, which had brought her to Darnell Pike, which had produced the citation now folded in her satchel. That evening, she sat at the small desk in her motel room and reviewed the paper again. She pulled up Georgia law on her phone, the full text of OCGA Section 15-1-3, which outlines the powers and jurisdiction of courts of record in the state, and read the relevant language twice. She pulled up the Calloway County website and located the page for the county court. She read the posted procedures for contesting a citation. She wrote the case intake number at the top of a new page in her notepad. The citation instructed her to appear before Calloway County Court no later than the following Monday. The presiding judge was listed on the citation form in printed letters, pre-filled at the top of every such document used in this county. Judge Otis Wren. Simone Cross set her pen down. She looked at the name for a moment, then she picked the pen back up and wrote, underneath it, in the same careful hand, Day 4, first formal contact incoming. She did not write anything else that night. The Calloway County Courthouse was a different building from the administrative complex, older, heavier, built from the kind of limestone that goes gray over decades and starts to look like it was always gray. It sat on the corner of Meridian and 4th, flanked by a pair of dogwood trees that were bare now in late October, their branches making angular patterns against the pale morning sky. Simone arrived at 8:50 a.m., 10 minutes before the 9 a.m. docket was scheduled to open. She had dressed the same as the day she received the citation: dark slacks, gray blazer, flat shoes. The satchel over her shoulder, the coffee cup in her left hand, though today she finished it before she reached the door and dropped it in the trash on the front steps. The interior of the courthouse smelled like old wood and floor wax, and the particular institutional stillness of a building that processes human trouble all day and locks it away at night. A bailiff at the security desk scanned her bag without looking at her. She retrieved it, settled the strap back on her shoulder, and found the posted docket on the bulletin board in the main hall. Her name was listed 7th on the morning session. 7 cases ahead of hers meant she would wait, likely between 45 minutes and an hour and a half, depending on how quickly Wren moved. She found a bench in the hall outside Courtroom 2, sat down, and opened her notepad to a clean page. Other people trickled in and arranged themselves on the hard wooden benches. A young man in his early 20s with a traffic citation creased in his hand. An older couple, the woman holding a manila envelope, both of them dressed carefully, as though the clothes might matter to whoever was listening. A woman about Simone's age who seemed to know the routine. She sat down without looking at the docket, opened a book, and began reading with the resigned patience of someone who has been here before. At 9:12 a.m., the courtroom doors opened, and the bailiff, not Darnell Pike, a different man, older, with a stiff left knee that gave his walk a slight hitch, called the first case. Simone listened. She was not trying to eavesdrop. The courtroom doors were propped open, and in the quiet of the hallway, the proceedings carried clearly. The first 3 cases moved at pace: a traffic matter, a zoning dispute over an unpermitted addition, a noise ordinance violation from a business owner who seemed to have appeared without a lawyer and was visibly unsure where to stand. Otis Wren's voice carried into the hall as a low, carrying baritone. He had the kind of voice that had learned, over decades on a bench, that it never needed to rise to fill a room. He interrupted often. He completed other people's sentences when he decided he'd heard enough. He issued his rulings the way someone closes a cabinet door, final, without looking back. The 4th case was a woman, black, 40s, contesting a code enforcement fine on her rental property. Simone could not see into the courtroom from where she sat, but she could follow the exchange by sound alone. The woman had documentation. She referenced it, the rustle of papers audible, and began to explain the circumstances of the violation. Wren stopped her before she completed her second sentence. "Ma'am, the finding is already in the record. We're here to determine the payment schedule, not to relitigate the inspector's findings." The woman said she had not been given an opportunity to contest the finding at the original inspection. Wren said, "That window closed 30 days after the notice was issued. The record shows you received the notice." The woman said she had not, in fact, received it. It had been sent to an address she had vacated the previous year, despite updating her contact information with the county. There was a pause. Then Wren said, in a tone that had just enough warmth in it to make the condescension harder to name, "Ma'am, I understand it feels unfair, but the county cannot be held responsible for mail delivery failures on your end. The fine stands, $240. You can set up a payment plan at the clerk's window." The woman did not respond further. Simone heard the sound of papers being gathered, a chair moving, heels on linoleum. When the woman emerged into the hallway, she did not look at anyone. She walked straight to the far end of the bench, sat down with her back very straight, and stared at the floor. The manila envelope was still in her hands, unopened. She had never gotten to use whatever was inside it. Simone watched her for a moment. She noted the envelope. She wrote 2 words in her pad. Then she turned the page and waited for her name to be called. 1 a.m., the bailiff read it from the door. "Cross, Simone Cross." She stood, gathered her satchel, and walked into courtroom 2. The room was smaller than she had expected, or perhaps it felt that way because Otis Wren occupied it so completely. He was a large man, broad through the chest, with heavy frame glasses and gray hair cut close at the sides. He sat on the elevated bench the way someone sits in a chair they have inhabited long enough that it has taken their shape. The seal of the state of Georgia was mounted on the wall behind him. To his left, at a lower desk positioned at an angle, Camellia Voss sat with a laptop open, her posture precise, her expression professionally pleasant. She was the same woman from the commission meeting Monday, the one who had offered and then failed to provide the visitor card. If she recognized Simone, she did not show it. At a table to the right of the room, County Attorney Bradley Carr sat with a single manila folder and an uncapped pen. He was in his late 40s, with the efficient, slightly rumpled look of a man who handles too much paperwork and has long since stopped finding it interesting. He glanced at Simone as she approached the respondent's position, a standing area marked by a worn patch of carpet in front of the bench, and made a note on his pad. Wren looked at his screen. "Cross, citation issued October 22nd. Alleged unauthorized approach of restricted access area, Calloway County Administrative Facility." He looked up over his glasses at Simone. "Are you represented today?" "No, Your Honor." "How do you plead?" "I'd like to contest the citation, Your Honor." Wren made a small sound that was not quite a sigh and not quite a hum, the sound of a man revising his estimate of how long this particular case would take. He sat back slightly. "On what basis?" Simone opened her satchel and withdrew a single printed sheet. She held it without brandishing it, the way you hold a document when you intend to reference it rather than perform with it. The citation references a posted county notice regarding restricted access. That notice does not cite an ordinance number or a statutory authority. Under OCGA Section 15-1-3, enforcement of access restrictions requires a lawful basis, either a posted ordinance reference or a standing court order. Neither was present. She read the statute reference from the sheet, not from memory, from the paper, calmly, the way someone reads a phone number they haven't memorized. Bradley Carr looked up from his folder. Camellia Voss's typing slowed. Wren's expression did not change precisely, but something behind his eyes rearranged itself. The slight recalibration of a man who has just had his expectation of a case quietly revised. He looked at Simone for a moment over his glasses. Then he looked at Carr. County's position? Carr cleared his throat. Your Honor, the county's posted notice constitutes sufficient public advisement under standard municipal administrative procedure. The respondent was advised of the restriction by the issuing officer at the time of citation, Simone said, still without heat. With respect, verbal advisement from an officer does not substitute for the statutory basis for the restriction itself. The notice board at the facility does not reference any ordinance. There's no code citation on the laminated card, and none was given to me in writing. Wren looked at her for another moment. Then he said, the ordinance question is a matter for appellate review, not this proceeding. His voice carried the mild authority of a man who has made this particular move before, framing the substance of a defense as procedurally improper in order to remove it from the room. This court finds the citation valid. Fine is set at $350, payable within 30 days. He reached for his gavel. Simone said, Your Honor, I'd like to note for the record that I was not permitted to complete my evidentiary basis before the court ruled. Wren's hand paused above the gavel. He looked at her with an expression that was almost curious, the expression of a man who is not often interrupted at this stage. Then the curiosity settled into something flatter. Noted, he said, for the record. He brought the gavel down. Next case. Simone did not move immediately. She folded the printed sheet back into her satchel, closed the flap, and settled the strap on her shoulder. She turned and walked toward the courtroom door. She did not look at Camellia Voss or at Bradley Carr. She did not look at the seal of the state of Georgia on the wall behind Wren's bench. But in the hallway, she opened her notepad to the page with the case intake number and wrote, below the date and the hearing time, a single line. Court denied evidentiary presentation prior to ruling. Statement noted for record. Then she wrote the fine amount. Then she drew a line beneath it and wrote, begin formal documentation. She uncapped and recapped her pen 3 times in quick succession. A small, contained motion, the only outward sign that anything she had just experienced had registered at all. Then she walked to the end of the hall, pushed through the heavy front door of the courthouse, and stepped back into the October morning. The dogwood trees on either side of the steps stood bare and gray against the sky. A van from a county utility department was pulling into the parking lot. Somewhere down Meridian Street, a truck was backing up, its warning tone carrying flat and regular in the cool air. Simone Cross stood on the top step of the Calloway County Courthouse and wrote $350 in her notepad, underneath everything else. She looked at the number for a moment. Then she turned the page and started writing the second entry of the day. The following morning, she was back at the library before it opened, waiting on a wooden bench outside the entrance with her coffee and her phone. When the doors unlocked at 9 a.m., she went directly to the reference section and requested access to the public court docket index for Calloway County for the years 2018 through 2024. The librarian, a quiet man in his 60s who wore reading glasses on a cord around his neck, produced a USB drive and a printed index guide without asking why she wanted them. Simone thanked him and set up at one of the Carroll terminals in the far corner, where a narrow window let in a rectangle of morning light that moved slowly across the desk over the next several hours. She worked methodically. The docket index ran to several thousand entries across the 6-year period. She was not looking for individual cases, not yet. She was looking at aggregates, fine amounts by case type, adjudication outcomes by race of defendant, where the record indicated it, continuances granted and denied, and at what stage, default findings, cases where the respondent did not appear or was not given adequate notice, and how they clustered. By noon, she had flagged 112 entries. She printed nothing. She wrote 3 pages of notes in her compact shorthand, the figures organized into a framework she would not share with anyone yet. She returned the drive and the index guide to the reference desk, thanked the librarian again, and walked to Maybell's for a late breakfast. She was on her 2nd cup of coffee when someone sat down across from her. Not someone she knew. A woman in her late 20s, compact and quick-eyed, with a press badge on a lanyard tucked into the pocket of her jacket where it wasn't quite hidden. She had a notebook of her own, a steno pad, the spiral at the top, the kind journalists carry. She set it on the table face down and said, "You were in Wren's courtroom yesterday." It was not a question. Simone looked at her. She did not answer immediately. "I go once a month," the young woman said. "I've been tracking his docket for about 6 months. I'm with the Calloway Courier, independent, not the county paper. I write what I want." She paused. "You contested the citation." "That's public record," Simone said. "Most people don't." Simone looked at her coffee. Then she looked back at the young woman. "What's your name?" "Jazmine Ford." "How long have you been tracking the docket, Miss Ford?" 6 months, since July. I started after a woman I know got hit with a $300 fine for an expired tags violation. The fine schedule posted on the county's website shows maximum $200 for that offense, but Wren's court has been running its own schedule. She opened her steno pad and turned it so Simone could see a handwritten table. "I've documented 41 instances where the fine amount exceeded the posted schedule. 37 of the 41 involved black defendants." Simone read the table from where she sat, without touching the pad. She was quiet for a moment. Then she said, "That's a pattern." "That's what I think too," Jazmine said, "but I don't have enough for publication yet." The county attorney's response to my records request cited an administrative adjustment provision. They're claiming the judge has discretionary authority to adjust fine amounts based on case-specific factors. There's no record of what those factors are. The adjustments are never stated on the record. Simone looked at her. "Have you filed a formal FOIA request with the clerk's office for the complete docket data?" 3 times. The first 2 were returned as incomplete, missing required form elements, according to Camellia Voss. The third one I had a lawyer friend review before I submitted. That one went in 6 weeks ago. I'm still waiting. Simone picked up her coffee. She drank the last of it. She set the cup down and looked out the window at the empty sidewalk. Then she said, without turning back to Jazmine, "Keep the FOIA open. Don't publish yet." She paused. "Don't mention me to anyone in that building." Jazmine looked at her for a moment. She had the instinct of someone who has learned that the most useful sources are the ones who don't explain themselves. She closed her steno pad and tucked it back into her jacket. She said simply, "All right." Simone left the diner 12 minutes later. She did not look back. The summons for the second hearing arrived with 8.29 in 2021. The summons for the second hearing arrived with people programs her social mean. The summons of noon she did not look back. She said that there recently, when I represent local, the summonly, it wasn't being to change that we were stating. She did not look back in just concern. She looked for Jazmine. She did not look back into the Darm. She did not look back into the Darm. Simone left the diner arrived in the second hearing arrived with people programs her social mean. She did not look back into the Darm. She did not look back into the Darm. Simone left the further diner where luck did know them. Simone left the different minutes of 12 minutes later. She said, she did not look back. She did not look back into the Darm. She did not look back into the Darm. Simone left the second hearing arrived with people programs her social mean. She did not look back into the Darm. She did not look back into the Darm. Simone left the second hearing arrived with people programs her social mean. Simone left the first does not another design. She did not look back into the Darm. She did not look back into the Darm. Simone left the second hearing arrived with people programs her social mean. The summon looked at which much un and me at the for the second hearing arrived on Friday, 3 days after the initial ruling. It was delivered to the Pineview Motor Lodge, which meant Camellia Voss's office had located her current address, which meant someone had checked. The summons was generated by the county court, signed under Wren's stamp, and cited new information relevant to the original citation matter. It required her to appear the following Tuesday at 9 a.m. Simone sat on the edge of the motel bed and read the document twice. She read the citation number, which matched her original. She read the phrase, "new information," which was not defined anywhere in the body of the summons. She read the production instructions at the bottom. Respondent is required to appear personally and to produce any documentation related to the matter at the discretion of the presiding court. She opened her phone and pulled up Georgia Code, Title 17, Section 5-30, the statute governing unlawful search and seizure, specifically the provisions requiring that evidence produced under court order must be tied to a documented evidentiary basis in the original record. The summons did not reference any such basis. She wrote the statute number in her notepad. Then she wrote, below it, in letters slightly larger than her usual hand, "Second formal contact. Escalation. Document everything from this point forward." That evening, she drove to the county library, which had extended Thursday evening hours, and requested a second session at the reference terminals. She spent an hour cross-referencing the 41 cases Jazmine Ford had flagged against the complete docket index. The pattern held and sharpened when she expanded the date range. Between 2018 and 2024, the fine amounts in Wren's court exceeded the posted schedule in 107 instances. Of those, 89 involved black defendants. The distribution was not uniform across case types. It clustered heavily in trespass violations, code enforcement matters, and what the docket listed simply as public order offenses, a category with no corresponding statutory definition posted on the county's public-facing legal resources page. She printed nothing. She wrote 6 pages of notes. On her way out, the librarian, the man with the reading glasses on a cord, was shelving returns near the front desk. Without looking up, he said, "We keep the printer paper locked after 7, but the copier in the reference room takes a standard USB drive." Simone paused. She looked at him. He continued shelving, face turned toward the cart. She said, "Thank you." He said, "Good evening." That was all. But she drove back to the motel thinking about what it meant. In a county this size, in a building this quiet, for someone to say something careful and useful to a stranger without being asked. She wrote one more entry in her notepad that night. Not everyone in this county has stopped paying attention. Some of them have just been waiting for the right moment to act on it. She capped her pen and set the notepad on the bedside table. The heating unit cycled on with its familiar rattle. Outside, the October wind pushed through the pines behind the motel lot. Simone Cross lay on top of the covers with her shoes still on, staring at the ceiling, and began composing in her mind, quietly and precisely, the first steps of what came next. Tuesday's second hearing had never made the seed the spinach, that to bring them she something settin', the first steps of what came next. Tuesday's second hearing had been delivered in your day, so that ultimately would any people concluded everywhere than made to member. Tuesday's second hearing had been living in thee to completely what all, that to bring them she some everywhere than made to play them. Tuesday's second hearing had been know in your day that members known for the aboutments of the Tuesday's second hearing. It is have more forecasting on Tuesday's second hearing had a different temperature from the first. Simone arrived at 8:45 a.m. and found the hallway outside Courtroom 2 already occupied. Bradley Carr was there, speaking in a low voice with a man Simone had not seen before. Compact, mid-50s, wearing a county sheriff's department uniform with sergeant stripes on the sleeve. The man's name tag read Vance, and he was holding a manila folder that he was apparently explaining to Carr. They stopped talking when Simone came around the corner. Carr's expression did not change. Vance glanced at her once, made nothing of it, and resumed looking at Carr. Simone found a seat at the far end of the bench. She opened her satchel and removed the printed sheet with the statutory references she had prepared. She had 2 sheets now, the original OCGA 15-1-3 reference, and a second page she had added 2 days ago after reviewing the summons, the section 17-5-30 language. She placed them both flat on the notepad in her lap and read through them once, unhurried, the way you review notes before an exam. The bailiff called her name at 9:08 a.m. This time, the room felt tighter. Camellia Voss was at her station, as before, but she was not typing. She was watching the room. Carr was at the respondent's table, but the folder in front of him was thicker than last time. And on the bench, Otis Wren had the quality of a man who has already made a decision before the proceeding began. A particular stillness that is different from judicial neutrality, the stillness of someone waiting for a formality to complete. "Miss Cross," Wren said. He looked at her over his glasses with an expression that was not unfriendly and was not the opposite of unfriendly. It was simply impersonal, the way large institutions look at small individuals. "This court has received a supplemental incident report from the issuing officer and from Sergeant Jerome Vance of the Calloway County Sheriff's Department. The supplemental report indicates that at the time of the original citation, you were observed in proximity to a restricted rear access corridor in addition to the main entrance, and that your conduct was consistent with attempted unauthorized access." Simone said, "Your Honor, I was not near any rear corridor. I was on the public walkway leading to the main entrance." Wren said, "The supplemental report documents otherwise." "I'd like to see the supplemental report." "The report is part of the case file." "Then I'm requesting access to the case file, which I'm entitled to under Georgia's Open Records Act." Carr said, without looking up, "The case file is available through the clerk's office following conclusion of the hearing." Simone said, "With respect, I can't respond to evidence I haven't been permitted to review. Under OCGA Section 17-5-30, evidence produced under a court compulsion order requires a documented evidentiary basis in the original record. The supplemental report was not referenced in my original citation and was not included in the initial hearing materials." Wren looked at her for a moment. "Miss Cross, this is an administrative citation proceeding. The rules of criminal evidence do not apply in this courtroom. The rule I cited is applicable to administrative proceedings where enforcement powers are invoked," Simone said. She said it without argument in her voice, just precision, the way you state a measurement. "I'm not contesting the court's authority. I'm requesting that the evidentiary basis be stated on the record before a ruling is made." Wren leaned forward slightly, not aggressively, just enough to let her understand that the distance between them on the bench was entirely at his discretion. He took off his glasses, held them loosely in one hand and said, "Let me be direct with you, Miss Cross. This court has seen visitors pass through who believe that citing legal codes substitutes for actual legal knowledge. It doesn't. This is a county court, not a law school exercise." He put his glasses back on. "The fine on the original citation is amended to $800. Court costs of $60 are added. Total, $860, payable within 30 days. Any non-payment will result in a failure to appear finding and escalation to the district court." He looked at Carr. "Anything to add?" Carr said, "Nothing, Your Honor." Wren reached for his gavel. "We're adjourned on this matter." Simone stood at the respondent's position. She did not move immediately. She said, "For the record, the court declined to provide the supplemental report for review prior to ruling, and declined to state the evidentiary basis for the amended fine on the record." Wren looked at her with the gavel still in his hand. Something moved through his expression, too quick to name. Then he said, "Noted, for the record." He brought the gavel down. This time, Camellia Voss was watching Simone as she turned to leave. Not with hostility, with the careful attention of someone filing something away. In the parking lot, Simone walked to her car. She was halfway there when she heard footsteps behind her, heavier and more deliberate than someone walking to their own vehicle. She did not speed up. She reached her car, put her hand on the door handle, and turned around. Darnell Pike was 10 feet away, not in his position at the administrative building today, off his standard post in the courthouse lot in full uniform. He had his hands loose at his sides. He stopped when she turned. "You need to understand something," he said. His voice had the same flat quality as the first morning. Practiced, unhurried, entirely sure of itself. "This county has a way things get done. You've been in 2 hearings in a week and a half. You've been in the library. You've been asking around." He paused. "People notice." Simone looked at him. She did not respond. "Wren isn't going anywhere," Pike continued. "This is his county. It's been his county for 18 years, and people here like how it runs. Whatever you came here to do, the smart thing is to take the fine, pay it, and go back where you came from." He let that sit for a moment, then he added quieter, "You've got maybe 24 hours before I find a reason for another citation. I'll find one. I'm good at finding them." Simone looked at him for a full 5 seconds. Not a confrontational 5 seconds. A measuring 5 seconds. The kind that precedes a note written in a pad rather than a response given in a parking lot. Then she said, "Thank you for telling me that." She opened her car door, got in, and drove out of the lot. Pike watched her go. He assumed she was scared, processing what he'd told her, deciding whether to run. He turned and walked back toward the courthouse. He did not think about what it meant that she had thanked him, specifically, for the information. He would think about it later. That evening, Simone sat at the small desk now and said, "What having measured depressant?" He did not think about it later. That evening, Simone sat at the small desk now and said, Then he said for the grope at the desk, but ability, when he bringing opening with Pike works. That evening, Simone sat at the small desk now and said, "To gnarly one she watch back marker, the desk a be which she combines over to work. One she works in path places, and had thinking on their desk by 2 them together when she works in path." Pike watched her go. He works good from them, for the desk could be quit there first. The desk could be what she was also, now, looking at a third document, a photograph she had taken on her phone of the parking lot as she drove out, wide angle, catching the building facade and the entrance where Pike was standing. She wrote a careful account of the parking lot exchange. She noted the time, 4:17 p.m. She noted that Pike had been off his standard post at the administrative building, which was a 1/4 mile away. She noted the specific phrases he had used. Maybe 24 hours. Find a reason. Find one. She noted that no other county employee had been present, that the exchange was unwitnessed in the lot, and that she had not provoked or contributed to the direction of the conversation. She dated the page, signed her initials at the bottom, and moved to a new page. Then she drafted a brief message to an address she had not used since she arrived in Calloway County. The message was 8 sentences. It contained no explanations, no narrative context, no requests. It contained a date, a location, 3 statute numbers, and a description of 2 separate court proceedings. She read it back once. She sent it. She put her phone face down on the desk and picked up her pen again. She wrote, Day 10, Formal Escalation Timeline Active. Jerome Vance, Supplemental Report. Evidentiary basis withheld twice on record. Parking lot contact from Pike. Time logged. Language logged. Third hearing likely incoming. Pattern consistent. Next steps. FOIA through alternate channel. Contact with Jazmine Ford for FOIA status. Locate any corroborating documentation on Vance's supplemental reporting history. She drew a line under it. Below the line she wrote, The fine is not the point. The fine is never the point. The fine is the mechanism they use to make people too tired to keep looking. She capped her pen. She looked at the motel room ceiling, the same stain in the corner she'd been noticing since Saturday, the heating unit cycling on with its familiar rattle, the October wind off the pines outside. Simone Cross was not tired. She was, if anything, the opposite. She had been in places like Calloway County before. She knew what it felt like when a system had been running its particular damage long enough that the people inside it had stopped noticing it was damage. when the weight of it had become so familiar that they called it ordinary, called it procedure, called it just the way things work here. She also knew what it felt like when that system encountered someone who had come prepared to measure it. She turned off the lamp and lay back. The wind pushed through the pines. The heating unit ticked and rattled. And somewhere across town, in the Calloway County Courthouse, the docket for the following week was already being prepared. Wren's name pre-printed at the top of every citation form, every fine notice, every summons, the way it had been for 18 years. For 18 years. But not for much longer. The morning after the parking lot exchange with Pike, Simone drove to the county's administrative annex on the south end of town, a separate building from the courthouse, lower, plainer, housing the offices that dealt with records requests, permit filings, and the small machinery of county administration that most residents interact with more frequently than any court. She had identified it 3 days earlier as the location where requests to the clerk's office were physically received. She submitted a written records request at the front counter, asking for the complete court docket index for Calloway County Court for the 6-year period, in the format specified by Georgia's Open Records Act, OCGA, Section 50-18-70. She filled out the form in her careful, compact hand. She included her full name, her motel address, a phone number, and a clear description of the records being requested. She handed it to the woman at the counter, a young woman in her mid-20s who was not Camellia Voss, but who glanced at the form with the particular blankness that people develop when they have been trained not to react to things they haven't been told how to react to, and received a stamped copy of the intake form in return. The statute required response within 3 business days. She noted the date in her pad. She drove back through town on the longer route, the one that took her along the residential corridor behind the courthouse, past the row of modest Victorian-era houses that had been converted into law offices and real estate agencies, and in one case, a bail bond service with a sign in the window that had not been updated since the previous decade. She was not going anywhere specifically. She was looking. She had learned, in the course of a career that had taken her to more than 30 jurisdictions over 19 years, that the physical layout of a county's legal and administrative infrastructure told you things about the relationships inside it that no document would. When the clerk's office and the courthouse and the county attorney's office were all within 4 blocks of each other, and when the bail bond service was directly across the street from the criminal court's entrance, and when the public parking for the courthouse was shared with the parking for the county commission office, and when all of it was walkable from the diner where the same faces showed up for coffee every morning, what you were looking at was an ecosystem, small, interlocking, self-reinforcing. It was not in itself evidence of anything. Ecosystems were not crimes, but they were contexts, and context was where patterns lived. She stopped at Maybell's for lunch, the same booth as before, by the window. She ordered without looking at the menu and watched the sidewalk while she waited. A woman with a stroller passed twice in opposite directions. She had a phone pressed to her ear and appeared to be conducting a long and unsatisfying conversation with someone in an office somewhere. A man in paint-stained work clothes came in, sat at the counter, and ordered coffee and pie. 2 men in county vehicle department jackets occupied a booth near the back. Everything was ordinary. She was most of the way through her sandwich when Jazmine Ford came in. Not by coincidence, Simone had sent her a brief message that morning after the records request, suggesting this time and place. Jazmine slid into the booth across from her without ceremony, already talking in a low, quick voice. "My FOIA came back," Jazmine said. "Partial response. They provided docket summaries for 2019 to 2021 only. The records for 2018 and 2022 through 2024 are listed as under administrative review pursuant to county records retention policy." She put the printed response on the table. "That's not a real category. I looked it up. There's no such holding provision in Georgia's open records framework." Simone read the response without touching it. Who signed it? Camellia Voss. Simone nodded once. She looked at the printed response for a moment longer, then said, The records request I filed this morning covers the same date range. Let's see if the response is identical. Jazmine looked at her. You filed separately. Under my own name, yes. Jazmine was quiet for a moment. She had the quality of a good journalist, the ability to not ask the questions she most wanted to ask, when she sensed that asking them would close a door rather than open one. She said, What do you think they're holding back in those years? Simone said, 2018 is when Wren ran unopposed for the third time. The years after 2021, I'd want to see the full distribution. She paused. The pattern Jazmine identified holds through what you have, but the oldest and the most recent data would sharpen the picture. What do we do if they stonewall the second request too? Simone said, There are other channels. She did not say more. She picked up the last quarter of her sandwich and ate it. Jazmine watched her. Then she said carefully, not looking up from her stenopad, I want to ask you something. You don't have to answer. Simone said, Go ahead. You've been in this county 10 days. You got cited, fined twice, and Pike threatened you in a parking lot. You filed records requests, you've been in the library, and you're still here. She looked up. What is it that you actually do? Simone looked at her for a long moment. Then she said, I work in oversight. She said it the way you say something that is technically true and deliberately incomplete. Jazmine looked at her for another beat, reading the edges of the answer, and then she nodded slowly and looked back at her pad. She did not push. What she did not know, what no one in Calloway County knew, because Simone Cross had arrived quietly and without announcement and had carefully said and shown nothing that would indicate otherwise, was that oversight was a word with a specific institutional weight in Simone's case, a weight that would, in approximately 4 more weeks, arrive in this county's courthouse with considerable force. But that was later. For now, there was a FOIA response that cited a non-existent records category, a parking lot warning from a deputy who believed intimidation was the same as authority, an $860 fine on a citation that lacked a statutory basis, and a judge who had been running his courtroom like a private arrangement for 18 years. Simone finished her water. She looked out the window. The woman with the stroller had come around again, still on the phone, still walking. The October sky above Calloway was the flat white gray of weather that can't decide what it wants to do. The leaves on the dogwoods lining the main street were holding on by habit more than anything else. Keep documenting, Simone told Jazmine. Every session you attend, exact language, exact amounts, chain of custody on your notes, date each page, sign it. Jazmine wrote that down without being asked. What about the supplemental report Vance filed? That's one I'll pursue separately. Simone stood, settled her satchel, and put some bills on the table. She looked at Jazmine. Don't print anything yet. I know. When the time comes, you'll know. Jazmine looked up at her. How will I know? Simone said, Because I'll tell you. She picked up her notepad. She walked to the door, pushed through it, and stepped out into the flat October afternoon. Behind her, Jazmine Ford sat in the booth and looked at the door for a long moment. Then she looked at her stenopad. She tapped her pen against the page twice, thinking. Then she wrote, at the top of a fresh sheet, Simone Cross, oversight. She looked at the words. She underlined oversight, slowly, twice. She had been doing this long enough to know when a source was more than they were saying. The question was never whether to trust that kind of source. The question was whether to be patient enough to let the story show itself. She had learned to be patient. She closed the pad, tucked it away, and flagged the waitress for her check. Abel arrived at the motel on Thursday. This one was different. It was not a county court citation. It was a formal notice from Bradley Carr's office, on county attorney letterhead, requiring Simone to confirm identity and purpose of presence in Calloway County within 48 hours. It cited, loosely and without specific code reference, county authority to investigate potential interference with administrative proceedings. Simone read it twice. She set it on the desk beside the 2 court papers and the FOIA intake stamp. She looked at the row of documents. She thought about Jerome Vance in his manila folder in the courthouse hallway. She thought about the timestamp problem she had noticed when Jazmine described the docket pattern, the way Vance's supplemental reports on the cases she had reviewed in the index tended to appear in the file before the initial hearing date rather than after, which was the opposite of their stated function as supplemental material generated in response to new information. She wrote that down. Vance Supplemental Report. Check filing timestamps versus hearing dates on flagged cases. She wrote Carr's letter into her log. She wrote the 48-hour deadline. Then she drafted her response. A single paragraph, handwritten on plain paper, stating her full legal name, her current contact address, and that she was present in Calloway County for personal business, and had no obligation to disclose further detail absent a lawfully issued subpoena or other court compulsion meeting the requirements of Georgia law. She signed it. She made a photograph of it with her phone before folding it into an envelope. She drove to the post office annex on the north end of town and sent it return receipt. On the drive back, she passed the courthouse. Wren's car, a dark blue county vehicle with a parking placard in the window, was in its usual spot near the side entrance. She had noted its consistent presence over the past week and a half, including on a Saturday morning when the building was officially closed. She wrote the Saturday time in her notepad when she got back to the motel. She thought about what the librarian had said. Not everyone in this county has stopped paying attention. Some of them have just been waiting. She thought about the woman with the manila envelope, the one who had emerged from Wren's courtroom with the papers still unopened, who had sat at the end of the bench with her back straight and her face carefully composed. She thought about Jazmine Ford and 6 months of docket records and a FOIA response that cited a category that did not exist. She thought about a bench that had been running since 1922 and a judge who had sat at its center for 18 of those years, long enough to have stopped distinguishing between the institution and himself. Then she stopped thinking about it, because thinking about it was not the same as being ready. She was already ready. She had been ready for 3 days. What came next was not a matter of preparation. It was a matter of sequence, the careful ordering of steps that had to happen in the right order to produce a result that would hold, legally and institutionally, long after she left Calloway County. She opened her notepad to a new page. She wrote, Week 2, pattern confirmed across all 4 data points, escalation authorized, proceeding to formal documentation stage. Next contact, Ezra Quinn. She set her pen down. She looked at the names she had written. Then she turned the page and began making a list. The list she made that Thursday night was not long. 7 items, written in the same compact hand she used for everything. Case numbers, statute references, names and dates arranged in a column without explanation. Anyone reading over her shoulder would have seen nothing remarkable. That was, again, the point. The items on the list were not actions Simone was planning to take. They were conditions she was waiting to confirm before the next phase moved forward. 5 of the 7 were already checked. The 6th, Vance's supplemental report, timestamps cross-referenced against the original docket entries, she confirmed the following morning at the library. The 7th she would not be able to check until a specific person arrived in Calloway County, and that arrival was now 3 days away. She spent Friday walking the residential neighborhoods south of the courthouse, the ones that ran along the old rail corridor and backed up against a stretch of scrubby pines before the county line. These were the neighborhoods where the majority of Wren's black defendants lived, according to the address data in the docket index. Modest houses, mostly well-kept, with the careful maintenance of people who own what they have and intend to hold it. Yards raked of their fall leaves. One house with a hand-lettered sign in the window for a small catering business. Another with a vegetable garden still holding the last of a late autumn crop. The tomato stakes bare but the row markers still in the ground, as though whoever planted it was already thinking ahead to spring. She did not knock on doors that day. She was not yet at that stage. She was orienting, getting a physical sense of the distance between where these people lived and the building where Otis Wren spent his mornings deciding what their presence in his county would cost them. It was perhaps a mile and a half on foot, less by car, short enough that the courthouse was a fixed point on the horizon of daily life here, visible and close, and not a place anyone seemed to go unless they had to. She wrote 2 pages of notes that afternoon and spent the evening reviewing the supplemental report timestamps she had confirmed at the library. The pattern was clean once you saw it. Of the 32 supplemental reports Jerome Vance had filed in cases matching her flagged docket entries, 26 carried filing timestamps that preceded the relevant hearing dates, sometimes by as little as a few hours, sometimes by 2 or 3 days. Supplemental reports, by their stated function, are generated after an initial proceeding reveals new information. Reports filed before the hearing has occurred are not supplemental. They are prepared. The distinction was small and technical, and in a county where no one had been looking at the timestamps, entirely invisible. Until now. She dated and signed the bottom of each page. She made a second copy of her notes and sealed it in a plain envelope, which she addressed to herself at her Atlanta address and dropped in the outgoing mail slot at the motel desk before 9 a.m. The librarian, the next time she came in, looked at her once over the top of his reading glasses and then went back to his work. He did not speak, neither did she. But when she left that afternoon, there was a printed page left face down on the carrel she had been using, a page she had not printed. She turned it over. It was a Georgia state government form, a request for formal review of a subordinate judicial officer under OCGA Section 15-1-24. The Judicial Qualifications Commission. Every relevant field on the form was blank, except for the case classification code, which had been filled in careful ballpoint, by someone who knew exactly which box to check. She stood at the carrel for a moment, then she folded the form and put it in her satchel. She looked around the library. The librarian was at the reference desk, helping someone with a microfilm reader, his back to her. He did not turn around. Some people wait a long time for the right person to walk through the right door, she thought. She did not write that down. Some things did not need to be in the notepad. She drove back to the motel in the low, amber light of a late October afternoon, the pines casting long shadows across the 2-lane road. And she was already thinking about the Judicial Qualifications Commission and what the timeline would look like from the filing of a formal complaint to a commission hearing, and what evidence would need to be in that file when it arrived. Ezra Quinn arrived on Monday. He came on a Monday. He came into the forced water period part in the concept that missed it in the formal complaint. Individual Ezra Quinn arrived on a Monday. He came into the show that no work that we won't know what a bid. Ezra Quinn to bring among the late Monday with Hostly removed the 17, and she was really looking for first place fully, which is just much shit as it depending this vary. Ezra Quinn arrived on a Monday. He came on a Monday with Hostly removed the 17, and she could see him ultimate more Monday lore. Ezra Quinn is removed to that past of our formal both of the chore that will made filing of what it released. Ezra Quinn was really listing and returning with when they come back to the file with the any commission that they would know that they've never moved them. Ezra Quinn arrived on a Monday. He came when it said that they doesn't see to this protectively for the impacted, and that proof that would not yet it out. Ezra Quinn arrived on a Monday. He came in a standard federal vehicle, gray, no markings beyond the plate, and parked in the lot of the county library at 8:47 a.m. Simone was already inside at the reference carrel when she heard the door. She did not look up from her work. She heard the librarian's voice, low, neutral, and then a response, quieter still. Then footsteps. Then, across the table, Ezra Quinn sat down and placed a thin manila folder on the table in front of him. He was a compact man in his early 50s, with reading glasses folded into his breast pocket and a suit that fit too well to be anything other than intentional. He looked at Simone and said, in the same register someone uses in a library, "Ms. Cross." Not her first name, not an explanation, not a greeting that announced itself. She looked up from her notepad. "Mr. Quinn." He opened the folder and turned it so she could see the top sheet. It was a 2-page document, formatted, official, bearing a header she recognized, and beneath the header, a docket number she had not seen before. New. Generated within the past 72 hours. She read the first page without touching it. Then she said, "The timeline." Quinn said, "Complaint filed today opens a 60-day review period. If the commission finds sufficient grounds, and they will, a formal hearing is scheduled. That hearing is not in this county. It's in Atlanta, commission chambers." He paused. By the time the hearing is scheduled, every supplemental filing, every docket irregularity, every fine that exceeded the published schedule, that entire record needs to be authenticated and organized for presentation. Simone said, "It is." Quinn looked at her for a moment. Then he said, "I know." He said it the way someone says something they've known for longer than the conversation has been happening. There was a pause between them. The library's heating system moved air through the ceiling vents. Somewhere in the stacks, someone was walking, the slow sound of someone running a finger across spines. Quinn said, "The supplemental report issue is going to be the most important element. Criminal referral, potentially, if the DA's office decides to look at it. But that's parallel. It runs on its own track after the commission process." Simone said, "What about Carr?" "The bar referral is already drafted. It goes in the same day as the commission complaint." He paused. "Carr is going to know within 48 hours that something is moving. Wren will know shortly after that." "What will they do?" Quinn thought for a moment. "Wren will do what Wren has always done. He'll treat it as an administrative inconvenience and wait for it to go away. He hasn't had a complaint reach the commission level in 18 years. He doesn't believe it can happen." He closed the folder. Vance is the variable. Vance knows exactly what those timestamps mean. If he decides to get ahead of it, he may talk. Or he may disappear into a union grievance and go quiet. Simone absorbed that. Camellia Voss. Clerk. She's institutional. She'll protect the institution, not Wren personally. If the commission proceeding looks serious enough, she may cooperate. Simone nodded once. She wrote 2 lines in her pad. She looked at the form she had been given by the librarian. It was already filled out in the sections she had completed over the previous 2 evenings. Every field precise, every code reference verified. She slid it across the table to Quinn. He looked at it. He looked at her. For the first time, something that was almost expression moved across his face. The recognition of someone who has done a careful thing carefully. He folded the form and placed it in the manila folder. "Ms. Cross," he said, standing, "someone is going to figure out who you are before the hearing, probably before the end of this week." She said, "I know." He nodded. He picked up the folder, tucked it under his arm, and walked back through the stacks toward the door. He did not look at the librarian as he passed. The librarian did not look at him. The door swung shut behind him, and the library resumed its usual quiet. Simone looked at the table in front of her, the notepad, the pen, the empty surface where the folder had been. She wrote, at the top of a fresh page, "Day 16, complaint filed. Timeline active." Then she underlined the last 2 words and sat for a moment with the pen resting in her hand. 16 days since Pike had blocked her on the walkway. 16 days since the first citation, the first fine, the first hearing where Wren had refused to let her complete a sentence. 16 days of notes, of library sessions, of diner booths and motel rooms, and a parking lot warning from a man who had no idea what he was warning her against. She put the pen down. She picked it up again and wrote, below the underlined words, "They are going to find out who I am. What matters is that when they do, every piece of this is already in the records." She was right about the timeline. It took 4 days about the time. It took 4 days about the time, and it took 4 days in the record. She was right about the time when she wrote about the underlined words. She was right about the time when she knew that was the timely to make a time to the underlined words. She was right about the time when she knew that every piece of this is already in the record. She was right about the time when she dropped to the other, which he did never put on words, or make all we didn't word. She was right. She was right about the time to the underlined words. She was right about the time and took 4 days about the time and took 4 days in the record. She was right about the time when she knew that was the timely to make a time to the underlined words. She was right about the time when she knew that where that the time when she wrote or make a time, they are going to find out who I am. What matters is that when they do, every piece of this is already in the record. She was right about the timeline. It took 4 days. It came through Camellia Voss, as Quinn had predicted it might, not through cooperation, but through the predictable channels of institutional self-protection. The commission complaint, once filed, generated a formal notification to the presiding county judge and to the county attorney's office. That notification did not name the complainant, but it included a docket number, and docket numbers have an intake date, and Camellia Voss, who had been managing the county court's administrative records for 11 years, knew exactly which name had appeared in what context on what date. By Thursday afternoon, Simone was back at the library when her phone buzzed. A message from a number she did not have saved. 3 sentences, no identification. The sender knew a complaint had been filed. The sender wanted to know whether there was anything that could be done to resolve the matter quietly before it went further. The sender did not explain who they were. Simone read the message twice. She wrote it, verbatim, into her notepad, noting the timestamp. She photographed the screen. Then she typed a reply. "This number is now part of the documented record. Please direct any further contact to the Judicial Qualifications Commission of Georgia." She sent it and put her phone face down. She looked at the library ceiling for a moment. Then she picked her pen back up and wrote, "They know." Clock started Thursday, 4 p.m. Jazmine Ford was at the library that evening. They had established a pattern of meeting there in the early evening, in the reference section, where the tables were large and the lighting was good, and the librarian had an admirable habit of not walking in that direction unless asked. Jazmine had been attending Wren's hearings twice a week and had added 14 new case entries to her documentation since they last spoke. She spread them on the table, each one a separate index card, case number, date, defendant name initials, fine amount, scheduled fine amount, the difference, and Jazmine's own hand-noted observation of what happened when the defendant tried to contest. The picture those 14 cards made, laid out in order, was not ambiguous. Simone looked at them for a long time without speaking. Then she said, "This needs to be authenticated." Jazmine said, "I have my notes, signed and dated. I have my press credential from the Courier showing I was present in that courtroom on each of these dates. And your FOIA response. Still partial, still outstanding on the withheld years." Simone said, "The commission is going to issue a formal record subpoena as part of the intake review. When that goes to the clerk's office, the withheld years come out of the administrative review holding and into the subpoena response pipeline. They can't stall a commission subpoena the way they stalled your FOIA." Jazmine was quiet for a moment, processing the mechanics of that. Then she said, "When does that subpoena go out?" "Within 30 days of complaint intake, possibly sooner." Jazmine looked at her cards. She looked at Simone. She said carefully, "What are you, exactly?" Simone said, I'm someone who filed a formal complaint. She said it without evasion and without performance. It was the most accurate thing she had said in Calloway County, and it was also the most incomplete. Jazmine recognized both qualities simultaneously. She was a journalist. She was built for exactly this kind of incomplete accuracy. She gathered her cards and said, "I'll have everything organized and authenticated by the end of the week." Simone said, "Good." The week that followed was the county's attempt to run out the clock. Bradley Carr filed a motion in the county court requesting that Simone's outstanding fine be converted to a civil enforcement matter, which would have had the effect of generating a lien-eligible judgment against her before the commission hearing could be convened. The motion was procedurally aggressive and legally thin. It relied on a local administrative code provision that had not been formally adopted into the county's published rules, a fact Simone documented and forwarded to the commission's intake office within 24 hours of receiving Carr's filing. The commission's counsel sent a brief letter to Carr's office, noting that the timing and basis of the motion would itself be reviewed as part of the broader complaint inquiry. Carr withdrew the motion 6 hours after the letter arrived. Jerome Vance, meanwhile, filed an amended supplemental report, the same report whose timestamps had placed it before the hearing it claimed to supplement. The amendment, dated the previous Friday, adjusted the timestamp in the file header. It was the kind of change that looks invisible unless you have a copy of the original, which Simone did, photographed on her phone the day she first accessed the docket terminal. The original version and the amended version now sat side by side in her documentation file, dated and verified. She added both to the commission's record submission with a cover note explaining the discrepancy. She cited the sequence. She attached the photograph. She did not characterize it as anything. No accusations, no language about intent or motive. She described what the record showed and let the record speak. Darnell Pike wrote a new citation and left it at the motel desk on a Wednesday morning. Simone was not there when it was delivered. The front desk attendant, the same young woman who had checked her in on Saturday 3 weeks earlier, left it in the door slot. Simone found it when she came back from the library at noon. The citation alleged that her rental vehicle had been parked in a restricted commercial loading zone on the morning of the 14th for a period exceeding 30 minutes. The 14th was the day she had been at the library from 8 a.m. to 12:30 p.m. The library's parking lot, where she had left the car, was 3 blocks from the commercial loading zone in question. The library's entry log, which the librarian maintained as a standard visitor record, showed her arriving at 8:03 a.m. and leaving at 12:27 p.m. She requested a certified copy of the entry log. The librarian provided it without hesitation on the county's standard records certification form, signed and dated. She added the certified log and the new citation to the commission file with a single cover note. Third citation issued. Documentation of respondent's location at the time of alleged violation provided. She noted, as she sealed the envelope, that the system was no longer trying to exhaust her with bureaucratic delay. It had moved to something more direct. Fabrication. The timestamp amendment. A parking citation for a location she had not been. These were the moves of a system that had realized it was being documented and had not yet recalibrated to the possibility that the documentation was more thorough than anything it had previously encountered. Simone knew what came after fabrication in places like this. The next phase was isolation, the attempt to remove allies, cut off access to resources, make the person standing against the system feel alone enough to reconsider. She had seen it before, in other counties, other courthouses, other rooms with sealed windows and the kind of institutional weight that made ordinary people feel, correctly, that resistance was expensive. What those systems did not factor in when they began the isolation phase was the librarian who left a form on a carrel, the journalist who had been keeping records for 6 months, the woman with the manila envelope who had emerged from the courtroom with her back straight and her documents still in hand. The small, patient network of people who had not stopped paying attention and had been waiting, sometimes for years, for someone to arrive who knew what to do with what they had been gathering. On Friday afternoon, Simone sat across from the woman with the manila envelope. Her name was Doris Hayden. She was 53 years old, and she had been trying, for 14 months, to contest the code enforcement fine that Wren had levied against her rental property. The property she had inherited from her father, who had owned it for 31 years, and which she maintained with the care of someone who understood what it had cost to acquire. The fine had been for a structural violation that the county inspector had cited, and then, according to two independent contractors Doris had hired, had not actually existed at the time of inspection. The fine was $480. The notice had gone to her old address. The contested evidence was in the manila envelope she had been carrying to that courtroom for 3 sessions, each time without being permitted to open it. She laid its contents on the table in Simone's motel room. The inspector's report, the 2 contractor assessments, photographs of the property dated and time-stamped by the camera, a letter from her former property management company confirming the address update they had submitted to the county, with the county's own date stamp on the submission, proving the updated address had been on file before the fine notice was issued. Simone read every page. She asked 3 questions. She wrote 1 page of notes. Then she told Doris Hayden that her materials would be included in the commission submission as a supporting evidentiary exhibit, and that the commission's scope of inquiry was not limited to Simone's own cases. It extended to any documented pattern of conduct by the presiding officer. Doris Hayden looked at her across the motel room's small table for a moment. She looked at the papers spread between them. She said, 14 months. Simone said, I know. She sealed Doris Hayden's documents into a certified mail envelope that evening. She added a typed cover sheet with the case cross-reference number. She drove to the post office annex before it closed and sent it overnight to the commission's Atlanta address. She sat in the car in the post office parking lot for a few minutes after. The November sky had gone dark early, the way it does in the Piedmont when the clocks change and the low country dark comes rolling in from the east. She looked at the streetlight on the corner, the mauves already circling it even in the cold. She thought about Doris Hayden sitting across from Wren 3 times with an envelope of evidence he had never permitted her to open. She thought about the woman in the catering house in the Southside neighborhood, the vegetable garden with the row markers still in the ground. She thought about the thousands of quiet losses that had accumulated in this county over 18 years, each one small enough to absorb individually, together forming something that had no name except the weight of it. She started the car and drove back to the motel. The commission hearing was 6 weeks after the motel. The commission hearing was scheduled 6 weeks after the motel. The commission hearing was scheduled 6 weeks after the complaint intake, faster than the standard 60-day window, which told Simone that the intake reviewers had found the documentation compelling enough to expedite. The notification came by certified mail to her motel, and a simultaneous notification went by the same method to Judge Otis Wren, to Bradley Carr's office, and to the presiding officer at the Georgia State Bar for the bar referral running on its parallel track. Simone read her notification, wrote the hearing date in her notepad, and drove to the library to tell the librarian. She did not explain why she was telling him. He said, "Good," without looking up from his work. She said, "Thank you." He said nothing else. She told Jazmine 4 that evening at the library table. Jazmine wrote the date in her steno pad and said, "I want to be in that room." Simone said, "The commission hearings are administrative proceedings, not public sessions. But what comes out of them becomes public record." She paused. "Have your draft ready." Jazmine looked at her. "I've had it ready for 2 weeks." The morning before the hearing, Simone packed her bag at the Pineview Motor Lodge for the last time. She returned the room key. She put the bag in the trunk of the rental car. She drove 1 full loop through Calloway County before she took the highway south toward Atlanta, past the courthouse on the corner of Meridian and 4th, past the administrative building with the laminated card behind plexiglass, past the library and the diner, and the residential streets where the dogwood stood bare, and the row markers still waited in the garden beds. She drove the loop at the speed limit, taking her time, looking at the county the way you look at something you've spent a long time studying and are about to close the book on. Not finished with it, the book would stay open for a long time yet, but at the end of the part where you were still figuring out its shape, she merged onto the highway and headed south. Did she look at south? The Judicial Qualification Commission holds its formal hearings, the formal working and identity. The Judicial Qualification Commission headed no more were fit when he subscribed, and they're worried to a voice of number one to the next menitary. The Judicial Qualification Commission holds its formal hearings and headed traditional work the build. The Judicial Qualification Commission holds its formal working, number one to the next menitary. The Judicial Qualification Commission holds its formal work to the next menitary. She merged onto the highway and headed south. The Judicial Qualification holds its formal work. The Judicial Qualification Commission holds its formal work. The Judicial Qualification Commission holds its formal work, number one to the next menitary. The Judicial Qualification Commission holds its formal hearings in a conference room on the 11th floor of a building in Midtown Atlanta. Not a courtroom, not a grand space, just a long table and chairs and institutional lighting, and the particular atmosphere of consequential decisions being made in an unremarkable room. Simone arrived 20 minutes early. She placed her satchel on the table assigned to the complainant's position and removed the documentation file she had been building for 6 weeks. It was no longer a collection of loose notes and printed sheets. It was a bound, tabbed record, 412 pages, organized chronologically with cross-referenced exhibits and a cover summary that ran 11 pages. Otis Wren arrived with an attorney, a downtown Atlanta firm, the kind that handles judicial defense work. The attorney was good. He was not going to be good enough. Wren sat at the opposite table and did not look at Simone directly. His expression had the quality of a man who has prepared himself to be unfairly treated and intends to find vindication in his patience. He had, she noticed, aged visibly in the 6 weeks since she had last seen him in his courtroom. The certainty that had sat so heavily on him in that space, the certainty of a man who had never been seriously challenged in the place he ruled, had thinned out. He looked like what he was, in this room, a county judge who had come to Atlanta to answer for his courtroom, and who was finding that the distance from Calloway County made the architecture of his authority feel a great deal less solid. The 3-member commission panel entered and took their seats. The hearing officer, a woman in her 60s with close-cropped gray hair, and the composed efficiency of someone who has conducted these proceedings many times, reviewed the materials in front of her and opened the proceeding. She stated the case number, the nature of the complaint, and the scope of the hearing. She noted that the proceeding was being conducted under OCGA Section 15-1-24, and that the commission had jurisdiction over the conduct of the named officer. She noted that the complainant had submitted a 412-page evidentiary record, which had been reviewed by the commission's intake panel, and that the panel had found sufficient grounds to proceed to formal inquiry. Then she said, "We'll begin with the complainant." Simone opened her file to the first tab section. She did not begin with the citation, or the first hearing, or the parking lot exchange. She began with the docket data, the shape of it, the numbers, the pattern across 6 years, and more than 1,800 documented cases. She read figures from the record. She cited dates and case numbers. She did not editorialize. She did not use words like corrupt or discriminatory. Those were conclusions, and conclusions were for the commission to draw. She described what the record showed: fine amounts that exceeded the posted schedule in 107 instances, with an 83% concentration among Black defendants across specific case categories. She cited the FOIA response that had withheld 4 years of data under a non-existent administrative holding provision. She noted the date of that response and the name of the signatory. She moved to the supplemental reports. She produced, from the tab section, both the original version of Vance's filing and the amended version filed after the commission complaint was received. She placed them side by side for the panel. She read the timestamp from the original. She read the timestamp from the amendment. She read the hearing date the original had purported to supplement. She let the numbers sit in the room without comment. Wren's attorney objected at 3 points during her presentation. The objections were technical: hearsay on one document citation, foundation on another, relevance on the third. The hearing officer sustained the first, noted the second, and overruled the third with a single word. The proceedings continued. When she reached the section on her own cases, the 3 citations, the 2 courtroom hearings, the parking lot exchange, the fabricated third citation, she read from her contemporaneous notes, dated and signed. She read the exact language Wren had used in each proceeding, taken from her in-room notes made within minutes of each adjournment. She read the language from Pike's parking lot warning the same way: exact words, time logged, location documented, context noted. No characterization, just the record. The section on Doris Hayden's case came last in the evidentiary presentation. Simone read from the certified contractor assessments, the address update confirmation with its county date stamp, the 3 hearing dates where Doris had appeared with documentation she was never permitted to present. She read the amount of the fine and the duration of the proceeding, 14 months from the original notice to the 3rd unanswered hearing appearance. The room was quiet when she finished. Not the quiet of impact, not theater, just the working quiet of a panel reviewing material that was doing what well-organized evidence does when it is placed before people whose job is to evaluate it. Bradley Carr's bar referral had been filed separately and was running on its own track with the State Bar's Professional Conduct Committee. Wren's attorney had presumably already spoken to Carr about the exposure there. The referral concerned the unsigned administrative code provision Carr had used as the basis for the enforcement motion, the one that had not been formally adopted into the county's published rules. The bar's preliminary response, which Simone had received the previous week, noted that the matter was under review. It was not a finding. It was the beginning of a process. That was what most of this was still: beginnings of processes. The commission would deliberate. Their timeline, under Georgia law, ran up to 30 days from the close of the hearing. Wren would continue in his position, technically, until a final finding was issued, though the standard practice when a formal commission inquiry was open was for the presiding judge to voluntarily suspend active hearing of contested matters pending the outcome. His attorney would advise that, and Wren would comply because the alternative, continuing to preside over adversarial cases while under commission review, would be the kind of conduct that turned a finding of misconduct into a finding of willful disregard. He would comply. He would sit in his chambers or go home and wait. 18 years of a courtroom that had been his world, reduced to a waiting room. The hearing officer closed the proceeding at 2:47 p.m. She thanked both parties for their submissions. She noted that written findings would be issued within 30 days. She gathered her materials and left the room with the other panel members. The door closed with a quiet, definitive sound. Wren's attorney said something to Wren in a low voice. Wren did not respond. He was looking at the table in front of him, at nothing in particular, at the surface of a table in a midtown Atlanta conference room, at the specific geography of a man realizing that the weight of what he had built was not, after all, as permanent as he had believed. Simone closed her file. She replaced the tabbed sections in order, closed the binding, and put the file in her satchel. She stood, settled the strap on her shoulder, and walked to the door. She did not look back. The commission's written findings arrived 23 days later. The cover letter ran 1 page. The findings themselves ran 41 pages, single-spaced, organized under 6 statutory headings drawn from the Georgia Code of Judicial Conduct. The commission found that Judge Otis Wren had violated Rule 2.2 of the Georgia Code of Judicial Conduct, impartiality and fairness, across a documented pattern of cases spanning 5 years of the submitted evidentiary record. It found that fine assessments had deviated from the published schedule without stated basis or documentation in the record of proceedings, and that this pattern of deviation was not consistent with the legitimate exercise of judicial discretion. It found that the supplemental report chronology in 4 documented cases raised questions warranting referral to the district attorney's office for independent review. A referral that was not itself a finding of criminal conduct, but which opened the door to a separate investigative track that would run for months before anyone knew where it led. The commission suspended Wren from the bench, pending further proceedings under OCGA Section 15-1-24. The suspension was with pay, for now, a preliminary status pending a formal removal recommendation, which required a second-stage proceeding with its own timeline. He would not be sitting in Courtroom 2 on the corner of Meridian and 4th for the foreseeable future. Whether he would ever sit there again was a question that now belonged to a process that moved at its own speed, without regard for anyone's impatience. Darnell Pike received a written reprimand from the county sheriff's department following an internal inquiry prompted by the commission's findings regarding the 3rd citation, the fabricated parking violation. The inquiry did not result in termination. It resulted in a reprimand placed in his personnel file and a reassignment from the administrative building entrance to a desk post in the records division. His union filed a grievance on his behalf, contesting the reassignment. The grievance was pending. Jerome Vance was placed on administrative leave while the district attorney's office reviewed the supplemental report chronology. He had, through his attorney, declined to make any statement. The leave was paid. His post-certification, the Georgia Peace Officer Standards and Training credential, required for sworn law enforcement, remained active pending the outcome of the DA's review. Bradley Carr's bar referral was under active review by the State Bar of Georgia Professional Conduct Committee. The preliminary communication from the bar indicated a process of 6 to 12 months before any finding would be issued. Whether the finding would be a public reprimand, a period of monitored practice, or something more significant depended on how the committee weighed the evidence and how Carr's representations held up under their scrutiny. Carr had retained counsel and was cooperating with the review, his attorney said in a brief statement. His office in Calloway County remained open. Camellia Voss retained her position as county court clerk. The commission's findings had not named her in a way that triggered a separate proceeding, but the FOIA response she had signed, the one citing the non-existent administrative holding provision, had been included in the commission record as an exhibit, and its contents were now public under Georgia's open records law. What that meant for her, professionally and institutionally, was something that would be determined over time rather than in any single ruling. Doris Hayden's fine was vacated. It happened through a motion filed by the county attorney's interim appointee, Carr having recused himself from the matter, in county court before a substitute judge brought in from the adjacent district. The motion was granted in approximately 4 minutes. Doris Hayden was not in the room when it happened. She learned about it from a phone call. She said, according to Jazmine Ford, who was present when she received the news, $480, 14 months. And then she was quiet for a long time. Simone Cross's 3 citations were dismissed on a motion filed the same day as the Hayden vacatur. The $860 in fines and court costs she had been assessed were returned by county check, mailed to her Atlanta address, arriving 11 days after the commission findings were issued. She received the envelope, opened it, noted the amount, and filed it in the back of the documentation file. She did not frame the check. She did not photograph it for any purpose other than the record. Jazmine Ford's three-part series ran in the Calloway Courier over consecutive Mondays. The first installment covered the docket data and the fine schedule disparities, concrete, numerical, documented. The second covered the supplemental report chronology and Pike's fabricated parking citation. The third covered Doris Hayden's case specifically and included, near the end, a single paragraph about a woman named Simone Cross who had arrived in Calloway County in late October and who described herself, when Jazmine asked for a title, only as someone working in oversight. Jazmine had written that paragraph 3 different ways before settling on the version she ran. She had wanted to say more. She had enough by that point to say considerably more. But she had also spent enough time in this work to know that the right amount of ambiguity in the right place serves a story better than the full answer. People who read that paragraph would lean forward. They would ask the question she had asked. And that question, asked widely enough by enough people, was its own kind of accountability. The series was picked up by a regional outlet the week the second installment ran, and by 2 national platforms the week the third ran, after the commission findings became public. Calloway County was, briefly and disconcertingly, a name people outside the Piedmont recognized. Wren did not speak publicly. His attorney issued a statement describing the findings as incomplete and indicating that Wren intended to participate fully in any further proceedings, confident that the full record would support a different conclusion. The statement used the phrase, "isolated departures from standard practice," which was the kind of phrase that lawyers choose when the facts are not available for choosing something stronger. On the morning the series' third installment ran, Simone Cross Crossinavin, Cenero Coton looks pleasant to the dead. It had necessaries for the busy, a bit of new quid before. On the morning the series' third installment was the series of the facts that races the department that made deprevents understand. On the morning the series' third installment ran, she had not been there since the day she drove south for the Atlanta hearing. She was in a different county, in a different state, at a different desk in a different library, with a fresh page in her notebook and a new set of names at the top of a new list. She did not have the newspaper in front of her. She did not need to. She knew what it would say. She uncapped her. Back in Calloway County, in the records division where Pike now worked, a single detail from the commission's exhibits had not been addressed in any of the proceedings, any of the findings, any of the public statements issued by any of the parties. It appeared on page 206 of Simone's evidentiary file. A brief entry in the docket index, administrative file number CR-2023-0917, cross-referenced to an email chain in the county attorney's archive. The email chain had been produced in partial form in response to the commission's subpoena. Partial form meaning 3 of the 9 messages in the chain had been provided. The other 6 were listed in the subpoena response as withheld under attorney-client privilege, a designation that had been noted in the commission record without challenge, not because it was undisputed, but because the privilege question required a separate judicial proceeding that had not yet been initiated. 6 emails, a case number that cross-referenced to a docket entry with no corresponding defendant name, an administrative archive that no one had been granted access to, and a commission suspension that was, for now, the boundary of what the formal record could reach. There was a detail like that in almost every case Simone Cross had worked. A thread that didn't quite end. A door that was closed rather than locked, which meant it could still be opened by someone with the right reason and the right sequence of steps, and the patience to wait for the moment when the system's attention was elsewhere. She had learned over 19 years that those threads were not failures, they were futures. The case file closed on what it could close. The rest waited, in the record, for whoever came next. Jazmine Ford, at her desk at the Calloway Courier, had made a note about that administrative file number the week the commission findings came out. She had put a star next to it in her steno pad and written beneath it in capital letters, "Follow up." She was patient. She had learned to be. The pines outside the Calloway Courier office stood bare in the November wind, their branches making angular patterns against the gray sky. Inside, Jazmine Ford turned to a fresh page. She wrote the date at the top. She drew a line under it. She started a new file. Some things take longer than one story to tell. Simone Cross never raised her voice inside that courthouse. She never made a scene in the parking lot, never responded to Pike's warning with anything other than 2 measured words. She documented. She verified. She built a record so thorough that when the moment came, the facts carried every ounce of their own weight without anyone needing to shout. That is the lesson Calloway County teaches. Not that one remarkable woman dismantled a broken system, but that the system only survived for 18 years because everyone who passed through it believed the weight of it was too much to lift alone. The moment someone arrived who knew how to measure the weight precisely and who had the patience to let that measurement speak, the architecture began to fall. Most of us will never walk into a commission hearing in Atlanta with a 400-page file, but most of us can do what the librarian did, what Jazmine Ford did, what Doris Hayden did, showing up 3 times with an envelope of evidence, refusing to stop believing it mattered, even when no one would open it. Document, stay steady, keep showing up. If this story reminded you that ordinary persistence is its own kind of power, share it with someone who needs to hear that today. And if you haven't subscribed yet, now is a good time. There are more stories like this one, and they are all worth telling.